Serious lawyers of Reddit, what are times when the jury made the wrong decision? I was a first or second year associate, second chairing a big case with a very seasoned lawyer. We represented the plaintiffs, the families of two teenagers killed when their car was T-boned and was cut in half by a car that ran a red light at nearly 100 miles per hour. The driver who caused the accident was uninsured, died at the scene, and had no assets. However, the driver who caused the accident was traveling so fast because he got into a dispute with two other guys at a bar. They were chasing him. Those two guys were driving a company car with a multi-million-dollar liability insurance policy covering it. But the chasers were able to swerve and miss the wreck, so they never made contact with our client's vehicle. We sued both the dead driver and the guys chasing him. We tried the case and spent nearly an hour in closing arguments detailing the concept of proximate cause, explaining that the guys chasing the dead driver did not have to be the sole proximate cause of the accident to share responsibility for the accident. They just had to be a contributing factor to the accident to share some portion of the liability. We asked for $3 million for each family. The jury deliberated for hours, and like a scene from a movie, the jury came back with a question for the judge: can we award more than the plaintiffs asked for? The judge answered yes. A few more hours passed, and the jury came back with a verdict. The jury awarded $6 million to each family, but they awarded the damages against the dead driver alone, letting he chasers off of the hook. The jury looked very pleased with themselves, and they looked surprised when the families didn't look pleased with the verdict. In the hallway after the trial, one of the jurors sought me out for an explanation. He asked me how much the families would get after lawyers' fees. I told him zero, and explained that the dead driver had no insurance and no assets as I watched the blood drain from his face. He looked mortified and started apologizing. Talking it through with him, it became clear that the jury didn't understand why we had sued the chasers in the first place, because they didn't hit our client's car. They had no idea what we were talking about when we did our detailed explanation of proximate cause. That is when I learned that jury instructions are essentially meaningless. I've had 4 criminal trials. One, I walked a guy that I'm about 90% sure he was guilty. A guy in a mask robbed and shot people, drove off, crashed his car and ran off. No one saw his face. My client was found in a field about a mile away walking around. The car bag was crashed was his grandmother's. Not guilty. Another one, my client robs a CI for the FBI. It was caught on video and audio tape. He was arrested immediately. I almost convinced the jury it wasn't a robbery because they couldn't prove he used the gun. I destroyed the CI on the stand. They eventually convicted him. The last one was a week before I left the office. Guy was accused of shooting his father-in-law in the hand. Only witness was the victim. He wasn't super credible. Some mere witnesses heard things that didn't quite match his story. My client had 3 alibi witnesses that weren't great, but to me were just extra. Alternate jurors said no way he was guilty. Judge told me no way they could vote him guilty. Voted him guilty. Talked to a few jurors after, and it became real apparent they voted guilty because my guy was a scary looking black guy. It really bothered me. 2 guys broke into the defendant's parked car, stole money, and then drove off. He saw them fleeing, got in his car, and chased them down a busy roadway in the middle of the day, shooting his gun 8 to 10 times out the driver's side window. He hit driver and caused their car to crash into a building. Both of the burglars were unarmed and died on scene. The jury acquitted him of everything except a misdemeanor gun charge. They had records and stole, but you don't get to kill people for non-violent theft. Drug cases, all the time. The most egregious are in jurisdictions like mine, sadly, where a new felony was created called possession with intent to distribute whatever class substance. It's a great way to escalate a situation for a variety of reasons. The first is that it activates school zone charges, whereas simple possession does not. In any reasonably large city, mapping out the places that aren't school zones is an exercise in hilarity. Indeed, it would probably be better evidence of intent to skirt drug laws if some guy took the trouble to avoid being in a school zone. The second is that subsequent offenses quickly introduce mandatory minimum sentences, and pretty harsh ones at that. Gotta cultivate that criminal record early and often. so later cases ramp up the pressure to cut a deal, even if the charges themselves seem weak this time. That charge, specifically, is an absolute playground for police officers to perjure themselves, and for prosecutors to bring in experts, usually police officers themselves. No conflict of interest there, no sir. To talk about how plastic bags and money and pretty much everything can be evidence of an intent to distribute. Meanwhile, many of these cases start with raids of homes where multiple people are all sitting around and of course drugs are in the house. Everyone gets arrested, everyone gets charged, and far too many judges refuse to sack up and apply the case law that covers issues like mere presence and the technical definition of possession. I literally tried a case where the judge said, on the record, at sidebar, that my motion for required finding of not guilty on the intent to distribute charge was a close call, denied it, and then watched the jury convict my client. Beyond a reasonable doubt, and of course he wouldn't overturn their verdict afterwards on a not guilty notwithstanding verdict, essentially a renewal of the previous motion. The war on drugs is a vanguard movement in the war on due process and the rule of law generally, make no fucking mistake, and sadly, it's a perfect storm in front of a jury. Minority client, police officers testifying both as primary witnesses and as experts. Drugs are evil, the community is ravaged by them. Gee, wonder if it's because it's a poor shithole? So everyone's sick of everything already, and most of the defenses do rely on a combination of highly technical legal definitions and the reasonable doubt standard. That last one is incredibly important, because let's face it, it's not drug selling, it's just drug distribution. And in a poor shithole city, everyone is doing that all of the time. But proving the charge beyond a reasonable doubt ought to be quite difficult. But it's not. Juries just go along for the ride. Oh, and motions to suppress evidence? Yeah, no. That requires a judge to sack up and act like a jurist instead of as a keeper. That does not happen very often. Hell, it barely ever happens, even when the police don't fucking bother to get a warrant. If there's a warrant, which is a process, that itself is a breeding ground for perjury by police officers, then you're basically completely fucked, unless the police fucked up so incredibly badly that you can raise a smoking gun level factual inconsistency. I've only ever done a mock trial, and I was given the very rare experience where the jury members told us afterwards why they decided the way they did, and I was very shocked. After being in law school for 3 years, you tend to forget that the average person doesn't have even a tenuous grasp of the law, and sometimes they don't have the greatest grasp in logic. Some of the reasons they gave were for the most trite things that us, as third-year law students, would have thought would be totally inconsequential. But like another poster already said, if it's at trial, that means that there's enough on either side that it got that far in the first place. An easy decision that was obvious would never get that far anyway. But it's definitely weird as a lawyer hearing very Esquire-esque reasons for deciding the way they did. Happens occasionally in criminal trials in Australia. Cases will get overturned on appeal because the appellate court will find that it was not open to the jury to find that a particular fact could be proven, and hence the whole case. Usually this stems from an evidentiary issue or an incorrect direction from the trial judge. Wood VR is a good example of various reasons where the jury got it wrong due to incorrect conclusions, judicial error, and evidentiary issues. If a man had stalked his ex after a breakup, stabbed her repeatedly, nearly decapitating them in the process, shot them in the head, and then left her body to rot, then called the police while they were at the scene because they just wanted to help, then attended their ex's memorial service and sent flowers to the family, then claimed domestic abuse at trial with no proof, even though they weren't married or living together, he would have got the death penalty. But Jodi Arias did not. One thing to keep in mind, most lawyers will only have a handful of jury verdicts under their belt. Well over 90% of cases settle in both civil and criminal law, where they call their settlement a plea bargain. I've been practicing for almost 8 years in civil litigation, and I've had one matter go to trial while I was working on it, and that was in an arbitration proceeding before a 3-judge arbitration panel. Also, as for wrong decisions, remember that 1. If there's a truly obvious right answer on a question, the case is more likely to settle out once the losing side sees the writing on the wall, and 2. On many issues, if there's a clear right answer, the judge will decide the question during the pretrial stage. In other words, typically an issue is only going to get to the jury if the answer is uncertain enough that both sides believe they have a chance to prevail, and if judge determines that there's some reasonable basis for the jury to decide the issue either way. Not saying there won't be good stories here, but there are a few filters that are going to reduce the number of stories that fit the question. Not my story, but years ago a friend served on a jury in Texas regarding a rape trial. The story was that a nice suburban woman got lost one night in the bad side of town. This was in the days before cell phones and GPS, so she parked her car near a phone booth and got out to make a phone call. She was then assaulted and raped by a group of men. The jury was mostly women, and the case was ironclad. My friend, a guy, thought it really looked like a slam dunk. The problem was that a few of the women started questioning the judgment of the woman, her integrity, and so on. They then started criticizing her choice of clothing, speculating that she had been drinking when she claimed otherwise, and wondering if there were other motives. My friend couldn't believe it. It was classic blame the victim, and they could not be convinced otherwise. At the beginning of the trial, the perpetrators looked like they were ready to accept their fate. At the end, they couldn't believe their luck. I was once called in for jury duty, and after hours of waiting they started asking questions. The one that got me removed was, do you have any strong religious feelings? And if so, which religious group are you associated with? I got ordained as a minister a couple of months ago as a joke, and so I thought I was answering honestly when I told the guy that I was a minister for the Universal Life Church. I was removed from the other people pretty fast after that. In my experience, juries gets things right more often than judges do. Judges are unpredictable, they misunderstand rules, they often aren't prepared. Something about having a group seems to average things out to where they tend to come to rational decisions, even if sometimes we don't like them. Also keep in mind that the easy cases don't usually get to trial, at least in the civil context. It's the ones with good and bad facts on both sides that get in front of juries. If it were obvious my client was going to win, the other side would have settled. That said, I'm usually convinced I'm going to win when we go to trial. I was a juror in one case, and this dumb fucking old white woman didn't want to believe one person's testimony because it was translated from Spanish. She thought he doesn't speak English and probably doesn't have a green card and was just saying stuff so he wouldn't get deported. Oj. Nuff said. Honestly, I'm not sure that the jury made the wrong decision. Oj killed them for sure, but I don't know if the prosecution proved that beyond a reasonable doubt. It wasn't entirely the fault of the lawyers. The lap badly mishandled a lot of the evidence, plus the judge let the trial turn into an absolute shit show. Some of the jurors were definitely influenced by factors that were not relevant, but I think you can make a decent case that they didn't meet the legal standard for guilt. The main problem with the Oj case is that the prosecution had all of the facts, but the defense was able to win over the jury by just arguing over every single piece of evidence that was put forward, which created a lot of doubt. For example, the Oj case was one of the first high-profile cases where DNA was used to link a defendant to a crime, so the prosecution had to bring in experts to explain everything from the basics of what DNA is up through how unlikely a false positive would be in a case like Oj's where there's blood all over the crime scenes. The defense was able to cast doubt on this evidence not by proving that the evidence was tampered with, but by proving that it was possible that some of the evidence might have been tampered with. Another example was that the prosecution was able to show that it was very likely the gloves at the scene belonged to Oj due to how rare those gloves were in that size, and by showing Oj's credit card records, but the prosecution blundered in letting Oj try the glove on, which famously didn't fit, which the defense was able to capitalize on. If the glove does not fit, you must acquit. Add in Oj's celebrity status and the political climate of the time, many people believed that a guilty verdict would incite riots on the level of the Rodney King riots, and it's not insane to see why the jury chose not to convict. Worked on a guy's case in Missouri, had 2 strikes, and got pulled over after a local gas station got robbed. Robber wore a ski mask. Client had a mask in car, but no money or gun. He was also very white and the clerk/witness said the robber was black at trial. He gets railroaded on no evidence and a small town jury hatred of anyone with a record. Guilty and given an enhanced sentence of 60 years. Had another client that passed out at a party. Underage girls fellated him while asleep. Prosecutor's argument that the law doesn't specifically protect for guy being hummed without consent. Shouldn't have passed out at party with underage girls. Guilty and 20 years. I'm not advocating. Kevin Ponis. 11 years to life. Spent 16 years in prison for having sex with 17-year-old who told him she was 18. I understand that rape in any fashion, statutory or not, is reprehensible, but I mean, I'm 32 now, and I see teenagers every day that actively try to look older and sexier than they are. To me it seems that he was made an example of, especially given the frequency that this exact crime happens nationally. He had a fresh marriage and a newborn child before his arrest. Again, not advocating, just seems life with 16 served was a bit harsh. In modern times, the problems have centered around incompetent legal counsel, questionable evidence admitted at trial, biased judges, and ambiguous laws, and the unequal enforcement of criminal laws have led to verdicts that were unfair, unjust, and failed to punish the Caucasian defendant or to protect the African American victim. The injustices did not start with the famous trial of the Scottsboro Boys, 1931, in Alabama, and did not stop with the acquittal of the brutal murderers of 14-year-old Emmett Till, 1955, in Mississippi. Many of the worst jury verdicts have involved African Americans as the victim.